Let's say that you and your spouse are in California and you create a joint trust to hold your community property, and then you go through a divorce. What happens to the property in that trust? Well, in a joint family trust, you usually leave everything to your spouse if you're the first one to die. And you probably don't want to do this if you're going through a divorce. You don't want things to go to your soon-to-be ex-spouse anymore. So we typically recommend that you revoke that joint trust, so the terms of the trust wouldn't apply to you anymore. Then you can create your own separate property trust to hold the assets that you receive from the divorce. But hold on, you can't transfer your assets into the trust until after the marital settlement agreement has been finalized. That's because there is an automatic temporary restraining order, an ATRO, on all assets while a divorce is pending. This is to make sure that one spouse doesn't take their money and hide it in the Cayman Islands or something during the divorce. We don't want that to happen. Now, the divorce process might take a long time, but you can't put your assets into your trust yet. So what happens to those assets if you die before the divorce is finalized and you haven't put those assets in the trust yet? Do you have to go through the full probate court process? So we often prepare an assignment showing the court that you want all the assets that you receive from the divorce to go into your separate property trust. That way, if you die while the divorce is pending, someone can bring a court petition to transfer your assets into the separate property trust and avoid a full probate court administration. I discuss all of this and more in my YouTube video, Estate Planning Strategies in the Midst of a Divorce, and I suggest you watch that.